Under Minnesota law, you have a finite amount of time to report a work injury. In other words, if you don't report it within those guidelines, your right to recover or right to make a claim is gone. And it is really important that people understand the importance of reporting your injury when it is reasonably known that you've sustained an injury. And I say that because the law looks at it based upon a reasonable person standard. And that's kind of, as we start thinking, well, what's reasonable? Who's reasonable? And that's very subjective. But what I tell people is that if you can go, ow, and you can go, I associate that to my work activities or work injury, you gotta report it, okay? Just because your doctor hasn't told you, or you haven't made a claim, no, it's when you think that you've had that injury. So when that's come to fruition, you gotta report it. Now oftentimes that's gonna be pretty clear if we have what I refer to as kind of the duh injuries. You slip and fall, you trip and fall, you have an accident, those are pretty cut and dry. You know that something happened and you're gonna do it. But oftentimes it may be not as clear. So if it's a trivial injury where it's like, hey, I think it's gonna get better, it really hasn't, and then it's something over time that it's getting worse and finally you associate it. Or maybe it's something where it's an injury that has taken time, where it's cumulative over hours, days, weeks, or months, and then finally it's just to the point where you can't get out of bed and you're just kind of like, geez, what happened? Again, the law requires that you report it. So when you have an injury, you got to report it immediately. You have an upwards of 180 days to report your work injury. Failure to report your injury within that 180 days is a bar, okay? And when I say bar, it's not the bar that you go to have a drink. It's a bar meaning that you can't get over it, all right? It's done. And so I've seen too often in my career, situations where people have come in and they say, look, I didn't want to report an injury. I didn't want to rock the boat. I was afraid of what they were going to do. I followed the advice of what my high school football coach said. Hey, just sort of rub some dirt on it and get back in there, right? But that is not a viable excuse, all right? And while I certainly understand it and I'm sympathetic, but the law does not allow that. And so you have an obligation because you have to afford the employer an opportunity, one, to investigate, and two, to see if there's ways in which to correct it or to help you. And the legislature has deemed that 180 days is sufficient amount of time for that to happen. And failure to report it means, again, that you're out benefit. So I would always encourage people that once they've made that connection, report that injury, even if they're not working with that employer any longer, all right? If they're finally like, hey, it was a result of those activities, fine, report it, okay? Then talk with a work comp lawyer, or talk with a work comp lawyer first. And hopefully that lawyer will give you the same advice that yes, that you need to report it, okay? Because when anybody comes into our office, and is contemplating, I am always gonna tell them to report it. Now, I understand that there's things that you want to risk, the same reasons that I've just mentioned to you before as to why people don't, and maybe that's part of your equation. But again, I am always going to say that you should report your injury because under the law has been written to allow you certain workers' compensation benefits for your compensable injury, and that's what workers' compensation insurance is there for. So I would always encourage that people, if they're contemplating reporting, that they talk with an experienced lawyer, and they can always call our office for a free consultation.